I wanted to discuss today what's going on in immigration court, the new performance metrics. And I want to discuss how they can link over to what's going on with regular green card applications and citizenship applications and all sorts of applications at the administrative level with USCIS. I want to discuss briefly first the metrics, and then at the tail end, I want to share how these issues can connect with and impact the issues when you file for a green card elsewhere, and why you need to be urgently careful when you go forward seeking immigration benefits. So let's talk about the performance metrics. The idea started late December last year and early January of this year, when the Attorney General, Jeff Sessions, announced the idea of performance metrics for judges. Performance metrics. That idea doesn't sit well with immigration judges for obvious reasons. They're being compelled to live up to a certain standard set by the Attorney General when everyone knows what happens at court is up in the air every day. You never really can predict what's going to happen in individual cases. But the Attorney General wants to change all that. The Attorney General does want to dictate the outcome. What he has said is that all cases in detention or custody are priorities for completion. That's not a surprise. That's long been supposedly the aim of immigration law enforcement. He's also said, however, that 85% of all non-status, non-detained removed cases should be completed within 365 days. By that, he meant that all cases where there's not a pending application outside of immigration court, such as an application for permanent residency through marriage to a U.S. citizen, should be completed in 365 days in immigration court. What he's saying is that we're going to rush things, we're going to speed things up. And as I will explain in just a couple of minutes, even this provision doesn't give immigrants as much hope as one would think. The third metric, he said, is that he only wanted judges to have 15% of cases sent back to the immigration court, meaning that someone would appeal or file a motion to reopen or reconsider, and they would rule favorably, the decision would be favorably against the ruling of the immigration judge. He doesn't want more than 15% coming back to haunt the immigration court. Now that is really a high standard. He's saying to the judges, you can't make mistakes, you got to make it airtight when you deport individuals, because I don't want anything coming back and having to be repeated in immigration court. Well, it doesn't work that way. But those are the performance metrics that the Attorney General is trying to impose on immigration judges. And they're due to go into effect on August 1st. So we're just about 30 days outside of these performance measurements being imposed on immigration judges. In addition, the Attorney General has issued some new memorandums in the last 60 days. I call them the three C's, and really they're not so much memorandums, but he's also taken it upon himself to issue rulings that are supposed to guide immigration judges. And the three C's are regarding continuances, closures, and completed cases. Continuances happen often at immigration court when a party is sick, an attorney is sick, when there's some evidence that has not been able to have been obtained in time for the judge to hear it, or for a host of other reasons. And yet, the Attorney General is saying, no, we're not going to allow continuances so easily. Administrative closures are like the big brother, the big sister of continuances, in the sense that the immigration judge says, we're going to take this off the calendar. We're going to take this off because the parties before me have a good chance to obtain permanent resident status, say through a son or daughter that's now 21 years old and a citizen. And so let's see how that turns out before they come back to immigration court where I have to adjudicate and look at their case as to whether or not they merit relief for having been here without documentation for X amount of years. That's in a nutshell how administrative closure works. And he is trying to tighten that up. And in fact, he wants to reverse it backwards in the sense that under the Obama administration, administrative closures were not frowned on. And in fact, they were seen as a favorable way of giving immigrant families the chance to have the immigrant members obtain legal status through USCIS, through affirmative filings, prior to the immigration judge making a final decision whether to remove or deport that individual. He wants to bring those, Sessions wants to bring those cases back, and that could be a problem. Completed cases, and as I said, he wants X amount of cases completed. In a sense, those are quotas. He's imposing quotas. And in the December and in January, he said that he wanted every judge to complete 700 cases per year. 700 cases per year in a 50-week period. Now, if you count the cases that might go real quickly, those individuals with a long record of criminal convictions, with obviously not the time requirement to be here, those cases might move quickly. But that doesn't mean that such individuals don't have a fight. In many cases, the criminal grounds can be attacked in a technical way. In many cases, some of those convictions might be long ago, and they might qualify for relief that predates the Trump, the Obama, and the Bush administrations. And so even in those cases that one would think are quick and simple, they may not be. They may be cases that require a lot more time. And in that sense, we can say thank goodness to the Supreme Court for the recent ruling on notice to appears, on the notice given to individuals to go to immigration court, which are called notice to appears, which I discussed a few weeks ago. Because prior to the Supreme Court decision, ICE and DHS had gotten in the habit of issuing notices to individuals to appear in court, but not saying a date and time. Now the Supreme Court said, wait a minute, they need a date and time. So think about this. With the need to put a date and time in, if the courts are already cluttered with a lot of cases, how are they going to get an immediate hearing? And in fact, they're going to have to slow down before they can put someone in court, which means, again, that Sessions just isn't going to have it his way. It's going to be a lot rougher on him and his attorneys to move things as quickly forward as he would like to. Well, and just last week, Sessions upped the ante to 750 cases that he wants completed per year. Let's look at the math. The math is this. That's 15 cases per week. Judge works 50 weeks a year. So you divide that by 50 weeks, that's 15 cases per week. That's 3 cases per day that Sessions wants completed. Now, let's assume that those are merits hearing type cases. Cases where you have to put together a bunch of evidence, say cancellation removal, where you're trying to prove hardship, and you're going to put witnesses on the stand, and you're going to have hundreds of pages of supporting documents. What is Sessions saying? I want 3 of those completed a day. And if he wants 3 of those completed per day, that means each case only gets 2 hours and 40 minutes. That's no time at all to put on a strong case. Is he going to be forcing then attorneys to just submit evidence, a proffer, or what someone will say, and say that's the only way we're going to accept declarations from individuals? Well, that's not going to work either. I mean, I'm hoping it doesn't work, and I'm hoping that every immigration attorney in America puts up a fight on anything that smells like that in the future. Now, even if, let's say Sessions gets his way, 750 cases, completed cases per year, 3 per day. Well, that leaves all these other cases that aren't going to be able to be handled, because the backlog at court right now is 700,000. Some of you might recall, many, many years ago, I did a video on the backlog in immigration court, and it's still quite a popular video, with the exception that some of the statistics are off. Back at that time, and I was just starting to film any videos and write blogs at the time, the immigration court was backlogged 350,000 cases. And boy, the immigration bar, we thought, whoa, that is such a huge backlog. There's no way the judges can handle that many cases. Well, now the number's 700,000, at least as of May, and it may be increasing since that time. Back when I filmed my video, we knew that 90% of the cases ended in immigration court, meaning that win, lose, or draw, no one was challenging at a higher court. It was over. And since the vast majority of cases are denials and defeats and removals, that meant a whole host of people were not challenging it by going up the ladder to the Board of Immigration Appeals or the Ninth Circuit in California and other circuits elsewhere to challenge the decisions. Well, now the statistics showing us 91%. So that needle hasn't moved much. When I had filmed the video years ago, the estimate was that 57% of cases at immigration court go forward without an attorney representing the immigrant. A recent study that I saw said the number was now 40%. I don't know that that's true, because the statistics came out of the mouth of a Los Angeles immigration court judge. That may well be true in Los Angeles, because Los Angeles has a lot of programs servicing immigrants at immigration court. But that may not be the nationwide statistic. So I don't know how close we are or far away we are from the former number of 57%. But even 40% is a huge number. Even 40% is a large number of individuals to be going to court every year without an immigration attorney. I've always thought that was a recipe for disaster. And I don't know why that happens. And in places like Los Angeles, where there's a lot of services helping individuals who don't have the economic means to defend themselves, there are services reaching out to individuals to try to give them some modicum of assistance to defend themselves. Now, when the backlog was 350,000 cases at immigration court, there were about 250 immigration judges. So the average amount of cases per judge that were assigned was a little over 1,200, 1,243. Now, with the backlog at 700,000, there are now 100 more judges, about 350. But what that means is that the backlog now is set at 2,000 cases per judge per year. So, okay, now let's look at Sessions' statistics. 750 completed cases, taking all the time of the judges during the 50 weeks. Well, what about the other 1,250 cases they have waiting for them when they return to their chambers? Oh, boy, Sessions is so far out. I don't know how he can imagine that judges can live under that kind of pressure. But let's look at it another way. Okay, 350 judges, 7,000 cases equals 2,000 cases per judge. Okay, now let's look at the amount of hours that a judge has to work. 50 weeks per year, 40 hours per week, 5 days per week. How many hours is that? It's 2,000 hours. So you have 2,000 cases for each judge, and each judge has 2,000 hours. So how is this rushing by Sessions going to work? The net effect, I think, will be that there's going to be a lot more appeals. The net effect is that the backlog is going to get even bigger because I'm assuming the majority of immigration attorneys representing immigrants are not going to roll over. they're going to fight and they're going to hold their ground, and that's going to force more motions to be dealt with at immigration court, more motions to be dealt with at the Board of Immigration Appeals, and more cases taken up to the Ninth Circuit. It's going to lead to an even bigger backlog. And then let's think about the extra law enforcement push by Sessions and the Justice Department. We know that they want to end the temporary protected status program. And we know come January, a lot of programs will just start folding up. Potentially, there's 200,000 new cases of individuals that are going to be without documents that could end up being referred to immigration court. In fact, when TPS ends, are they going to get a notice from USCIS saying you now have to report to immigration court? And they're going to get a notice to appear, hopefully with the time and date on it, or that's going to backlog the courts even worse. What about DACA? If DACA dies, if DACA doesn't survive, are they going to put 400, 500,000 more individuals in immigration court that had once received DACA benefits? And as I noted, what about all those individuals who had received administrative closure under the Obama administration? Conservative estimate is 200,000. So if you were to add those numbers, you're talking about 800,000 new cases being sent to immigration court. So the Sessions idea of rushing cases is to take all of those and give them 5 minutes in court and get them out. No, that's not going to work. He's not going to be able to work like when he took, remember he sent those judges, a host of judges to the border for 3 weeks and posed it there so that they could do cattle call deportations, line up 10, 15 people at a time and try to deport them all at once, and therefore get his numbers up, get more people out, and maybe help judges hit their quotas. No, that's not going to work. That's not going to work. And if anybody has a client in one of those cattle call situations, I would say attack it with a passion. I once had a case where I had an individual came to me years later, 12, 13 years later. And when I pulled the immigration records from immigration court and I made a copy of the tapes, I found out it was a cattle call. And this person didn't speak English. So it was clear that they had a big problem with due process. That case got reopened and the individual eventually won permanent residency status. But that's easily what could happen. And immigration lawyers have to fight anything resembling a cattle call. Immigration lawyers have to fight all of these new provisions. They have to stand up and fight. And if you're on your own, you have to stand up and fight. And if you have a lawyer, you have to make sure they stand up and fight. Don't let Sessions get through with this. Okay, so now let's get to the effects, which is what I really, really wanted to get through. The effects are pretty obvious. Look, there's not going to be enough time for a judge to weigh the full evidence of cases under the Sessions plans. There's not. And that's where immigration attorneys have to step up their opposition. There's not going to be enough time between hearings for individuals, if they're going to rush and try to complete cases within 1 year, to do an adequate job on really difficult issues like developing the supporting evidence for an asylum case, developing the evidence for something like a hardship case where you have to prove certain family members are suffering an exceptional and extremely unusual hardship. It's not going to happen within the time work, whether it's 1 hour or it's 2 hours and 40 minutes. It's not enough time. And the Sessions plan, I'm going to keep saying it again and again, is not going to work. And lawyers and immigrants and family members, they have to stand up and fight this and force the slowdown of the Trump train. It harms judicial integrity. And along that lines, I'm glad to see that the National Association of Immigration Judges is taking a strong stand and challenging Sessions and saying, wait a minute, we're not a law enforcement court, that we're not a quota-driven body. We're here to do justice within the constraints of immigration law. Now, Of course, immigration laws, driven by politics, is slanted against immigrants, but you don't want it slanted even more with the help of Sessions. And I'm glad to see immigration judges taking that stand and standing up. And as I said, it's a violation of their duty to do fairness. It's a violation of their duty to do justice. It's a violation of their duty to do due process, fundamental fairness. One judge speaking before Congress noted that between the period of February 1st to August 31st of this year, it looks like about 78% of all cases, individuals were deported or voluntarily departed. Wow, that's a lot, 78%. That's over three quarters. And you figure a certain percentage are unrepresented, say 40%. But and then if the 9% appeal rate, because if 91% of cases stop at immigration court, 9% go on, and I would assume most of those are appeal type cases. That alone would be 6,000 cases going up to the BIA, and the BIA can't handle it either. They don't have the manpower to handle 6,000 new cases, and that's just one court, albeit one of the largest court. And one of the other points that's really significant here is that only 15% of immigration court cases do not involve a translator. So you got all of these cultures coming in, and you're telling people to rush, and they don't even understand the rules, and you're not giving them enough time to get the evidence. And then you're going to have translators trying to explain all this. It's a mess. Immigration court's a mess, and it's going to be a bigger mess. And unfortunately, justice is demanding that we fight it, which might even make it an even worse mess. Anyway, okay, here's where I wanted to go with those who are applying outsider court, which is called in immigration court parlance a collateral matter, which is why did judges don't want to give continuances? Because you have a collateral matter, you have a green card. Well, I don't know when USCIS is going to get to your case, so let's just let this end right now, right here. That's a real issue. That's a real issue. But even worse, I want to take it from the other side. You apply for a green card. You're married to a U.S. citizen. Maybe you've been grandfathered in. Maybe you actually enter legally. And you have a chance to win permanent residency. And you go to immigration court. And now they have these new USCIS rules that if you're missing something, and those are supposed to go into effect in September full force, and you're missing something, could be something minor, and they can deny you right away. And they can send you a notice to appear at immigration court. Oh, that's the connection. You go to USCIS, you file for a green card, you file for permanent residence, you file for citizenship, you make an error. They're no longer going to give you a request for evidence, a second chance. They're no longer going to give you a notice of intent to deny. Instead, they're going to deny you outright, and they might issue you a notice to appear at immigration court. That's if they don't call you in and serve you right there on the spot. And so now you have to go to immigration court, and everything at immigration court is rushing like crazy, so that you get to immigration court and the judge says, I don't have time for collateral matters. I don't have time to continue your case. We can't administratively close it. You have to go forward now. Oh, but you only got so much time to get your evidence ready. You only got so much time for your hearing. And I only got so much time to listen to your case. That's the master plan. And you need to know it. And you need to fight it. And you need to make sure everybody that's on your side on this issue of the political fence and knows immigrants' rights are being trampled on, you have to stand up and you have to fight this, and you have to make sure that if you hire an attorney, that they're fighting for this. You got it? It's going to be a battle. Let's do it. Thanks for watching. Know someone who might be interested in this video? Then please take a moment to like and share it with them. Also, if you would like more videos on immigration, just click on the subscribe button. And here's a little bonus, a short guide that you can download for free by clicking on the link on the description box or the square-shaped image. Plus, if you have ideas for videos you'd like to see, write a short comment below or feel free to contact me at carlos@lataraimmigrationlaw.com. My name is Carlos Latara. I appreciate your time and hopefully we'll be talking again very, very soon.